And welcome to this video where we will be looking at the topic of investigations. So even in the best case scenarios, when the business is running as usual, there are bound to occur some incidents, and those incidents may require investigation. The output of an investigation is the proof of something has happened, which tends to come out, and the proof also has to go through a cycle to be admissible, for example, in court of law. So, what is that requirement for having the proof based on the investigation that we are having? For example, administrative investigations are also called as internal investigation in the terminology of ISC². So if your company or the corporate that you are working with is conducting an investigation of a fraud, of a action that is considered malified, then that investigation is administrative in nature. Out of the investigation, the proof that comes out has certain features that it must fulfill. For example, the burden of proof. So the plaintiff or the person accusing of wrongdoings has to prove that the claim which has been made against the other person or the other party has to be produced by the accuser. So the burden of proof is not on the defendant. Then, while applying for the proof, there are certain standards which needs to be followed both in case of the civil and criminal cases. For example, in civil case, there is preponderance of the evidence, which means the evidence shows that the defendant is more likely in a majority vote, more than 50% of the time, to have caused the damage to the plaintiff. And this is used in the civil cases. While in criminal cases, the standard is much more strict because it may end up for the defendant to get jail or a hefty fine. Therefore, the proof in the criminal case has to be beyond reasonable doubt. Evidence has to be compelling and clear for a reasonable person to have no doubt of the or the reservation about the defendant. So this is used in the criminal cases. Now, a question that we as a security professional may ask at this point of time is that in the era of evolving AI, where the deep fakes have already causing a lot of security issues, is it possible to have an evidence which is beyond reasonable doubt? And that is a question that the security community have to answer together. In terms of the evidences that needs to support the proof, they also have characteristics. For example, a real evidence, tangible, something which you can touch, or a physical object like a hard disk or a USB. Drives, but the data on them is not tangible. You cannot touch the data. The direct evidence is the testimony from a first-hand witness. For example, what has been experienced with the five senses that a person possesses. Circumstantial evidences to support the circumstances for a point or other evidence. Collaborative evidence are supporting evidences which may not stand alone on its own, but they corroborate the main evidence. Secondary evidence act as a feeder to the primary or the main evidence, for example, logs in case of an IT system, which will help prove the actual evidence that has been submitted. Now, hearsay is also an evidence, but it is not admissible in the court of law because this is normally based on the first person knowledge of you have something heard about it or you have you know something about some instances of action being taken, but you are not directly involved with it, so it's hearsay. Now, computer generated records, for example, in case of the secondary evidences, it is that the log files can be used, but they have to be untampered. Otherwise, it will be considered as hearsay and then probably not applicable in the court of law. So the important point to consider for the evidence is that evidence should be untampered, non-formulated, and not planted. There are exceptions though in terms of the definition, which we will see in the next slide. For example, the best evidence is that is accurate, complete, relevant, authentic, and convincing. The integrity has been maintained. For example, the hash value before gathering the evidence and after taking the evidence must match. So that's any evidence of being tampered can be ruled out. The chain of custody, it is important that the evidence remains untampered, which can be proven by who handled it, when did they handle it, what did they do with it, where did they handle it, and stuff like that. Also, the way evidence has been gathered in terms of searches, reasonable searches. The different countries have different laws around it. For example, in US, the Fourth Amendment actually protects citizens from unreasonable searches and seizure of evidence of any sort by government. The ultimate ruling on evidence gathering remains with the court. In terms of your corporate or organization policy around it, it is always beneficial that you ensure that the employees of your organization are aware of what actions are being monitored. You can imagine taking a break or using a restroom probably is not the things to be monitored. Now, in terms of how evidence are based upon something, for example, if it's an entrapment, it is not okay. It's not admissible in court of law, and it is not taken as in real evidence. For example, when someone is persuaded to commit a crime, when they had no intention, and then charged with it, that is entrapping a person, and that is not admissible in court of law. In case of enticement, it has a legal and ethical means. For example, you make someone commit a crime more enticing, but the person has already broken the law or at least have decided to go. Cases like this are used in, for example, narcotics, where the person is already involved in transaction, but he or she has been enticed to do a transaction which can then be caught and recorded and can be used against the person in court of law. For example, honeypots is a good way of doing this. But then, if there is a gray area how even enticement has been done, then it is up to the jury. For example, in US judicial system and the jury system, it's up to the jury to decide which one it was, whether it's an entrapment or enticement. Now, in case of using honeypots, it is always better if you are in corporate frauds and investigation to check with your legal team what policies that they may follow and what outcome or consequences that may entail. Do understand that both entrapment and enticement carry legal and practical risks, so it must be contained and it must be well thought of. I'll stop here and I hope to see you in next video. Thank you very much.